Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Thank you for your time. Goodbye. Hello and welcome to a special interview for The Wire. Has the Supreme Court made a terrible mistake in what is now increasingly being called its Teesta settlement judgment? Has it converted the complainants into accused? And has it forgotten what it said in 2004 about Narendra Modi and the government he ran in Gujarat at the time? Those are three of many questions I should put today to one of the most illustrious former judges of the Supreme Court, Justice Madan Lokur. Justice Lokur, I want to talk to you primarily about what is increasingly being called the Supreme Court's Teesta Setalvad judgment. After accusing the complainants of false claims and an attempt to create sensation, the judgment says, and I'm quoting, "As a matter of fact, all those involved in such abuse of process need to be in the dock and proceeded with in accordance with law." As a former illustrious judge of that same court, how do you view this critical sentence?
Well, I think it's very, very unfortunate. There's no need to say all this. I mean, when you're dismissing a case, right? In this particular case, the appeal filed by Zakia was being dismissed. All right, it's been dismissed. But why is it necessary to say that, we are dismissing the case and we want you to be prosecuted because you have come out with a false case? Well, there are so many thousands and thousands of false cases that are filed. And are the courts going to prosecute everybody in all those cases? What about, false cases filed by the police? Is the court going to prosecute the police for filing false cases? So I think it was totally unnecessary and very, very unfortunate.
In a piece that you wrote for The Wire that was published earlier this afternoon, you said if the Supreme Court actually intended that Teesta Setalvad should be arrested, your words were, "Heaven help us." It's as bad as that, is it?
It's as bad as that, yes. Yes. Because then a litigant, if a litigant comes to court, and does not succeed, that litigant is in trouble. So I think we have to be very careful.
In other words, if a litigant comes to court and doesn't succeed and the court then decides that the litigant should be prosecuted, heaven help the litigant. Heaven help the litigant.
Yeah, certainly. Yeah.
You said something else as well. You said if the court did not intend that Teesta should be arrested, they should issue a clarification, and you added they should order direct unconditional release. 3 days have passed since she was arrested. There hasn't been a word from the court. What do you make of that? Total silence.
Yes. Well, I think really I don't know where the learned judges are, whether they're in Delhi or they're elsewhere, because this is vacation time. But surely, they could have instructed the Secretary General of the Supreme Court to issue a statement or to issue a clarification saying that, listen, it was not our intention that, Teesta be arrested and taken away to Ahmedabad. I suppose she's been taken away to Ahmedabad and, questioned. I think they could have done that. And if they are in Delhi, I think they should have a special sitting and, issue a clarification.
And if they haven't done that, what will be your response?
Well, I would feel extremely sad, extremely disappointed. What else can one do?
Disillusioned as well?
Disillusioned, yes, to an extent, yes, certainly. Yeah.
So today we have a position where one of the most illustrious former judges of the Supreme Court is actually disillusioned with what I might call your alma mater.
Yes, yes. And well, it's not only this judgment, but things have been happening in the past, and well, it's culminated in a sense in this judgment. But there have been instances in the past where the Supreme Court should have acted but did not. In this particular case, it should not have acted, but it did, So, yeah, I don't know what's going on.
In other words, there are multiple instances where the Supreme Court should have acted but did not, or cases like this where it should not have acted but it did.
Yes.
This means there are multiple reasons why you are disillusioned. This is not a one-off. This is not the only thing.
No, this is not the only thing. I mean, there's so many cases that are pending, habeas corpus and so on, electoral bonds. Why are they not being heard? And when in habeas corpus cases, people are in jail, they're in custody. So surely they should be given priority.
You've written about many of these. You've spoken to me about several of them. Your voice has been heard loud and clear. Has anyone from the Supreme Court ever got back and explained quietly, privately what the position is? Or is there total silence from them?
No, nobody has got back to me. Well, I suppose since they've not got back to me, I don't know whether they've got back to anybody else, but they've certainly not got back to me.
Let's then at this point, Justice Lokur, look at some of the implications of what I call the Teesta Setalvad judgment. First of all, it converts the complainants into the accused. And in turn, that seems to suggest that Indians don't have a right to challenge government actions or to question the conclusions of a special investigation team. That's a disturbing ramification and implication, isn't it?
It is. You see, because there are instances where special investigation teams have been appointed in criminal matters, right? In civil cases, there are committees that have been appointed, all right? Now, if what the committee says or what the special investigating team says is to be taken as something cast in stone, right? Then what happens and why do we have courts? Okay, so you just say that the matter has been referred to the SIT and that's it, end of the matter. Or it has been referred to a committee of maybe retired judges or experts, depending on what the nature of the case is. And the matter is closed.
But you're saying something even more important hidden behind that answer. If judges won't allow you to question the conclusions of a special investigation team, then judges are not doing their job properly either. Because questions will arise and those questions must be asked and those questions must be answered. But if they're not permitted, and worse still, if people are punished for asking them, then judges aren't doing their job.
Yes, you could put it that way. You see, because whatever the decision is taken, whether it's taken by an SIT or whether it's been taken by a committee, the decision is not necessarily correct, right? It can't always be correct. So a litigant or a person aggrieved has an opportunity to question that report. Okay, the Supreme Court itself has said that we are supreme, but that doesn't mean that we are infallible. Okay, the Supreme Court has itself recognized that. So how can it be said that an SIT or a committee or a commission is infallible? That's absolutely wrong.
The judgment also refers to what it calls, and again, I'm quoting the judgment, the audacity to question the integrity of every functionary involved in the process. That very language suggests that ordinary Indian citizens like you and me don't have the right to question the behavior of government functionaries because it's considered audacious to do so.
Yes, I think the language is very unfortunate, harsh. It should not be, particularly in criminal cases. Language should never be harsh. because the litigant has suffered. I mean, in this particular case, you can imagine what Zakia has gone through. And then to say that she has the audacity to say that the SIT is wrong, I think it's totally uncalled for.
But beyond the harshness of the language, there is a sense of prejudice behind the language. You only say it's audacity to question an SIT if you firmly believe the SIT, as you said, is infallible, and you're indicating a prejudice clearly in its favor and against the litigant. This is prejudicial use of language, not just harsh language.
Well, yeah, okay. I am prepared to give the benefit of doubt to the judges. Yeah, and perhaps what you say may also have led to the fact that the Supreme Court has said that you put them in the dock. Could be.
Let me go one step further. The judgment says, and again I'm quoting from the judgment, inaction or failure of some officials of one section of the state administration cannot be the basis to infer a pre-planned conspiracy by the authorities of the state government or to term it a state-sponsored crime against the minority community. But doesn't that statement overlook the fact that inaction or failure by one section of officials could be a response to direction and command from the top and not incompetence or ineptness? They can be told to deliberately fail, which they often are, with a nudge and a wink.
It's possible. It's possible. I don't know whether this argument was even placed before the Supreme Court when the matter was being argued. But yes, you're right. Instructions can be given to people, to bureaucrats, to the police, that, do this or don't do this, do that or don't do that. It's possible. But whether this was actually placed before the Supreme Court as an argument, I don't know. The judgment doesn't seem to give any indication. It just seems to suggest that, one section did not do their job when it should have done their job. But for that, you can't blame the entire administration.
What do you make of the fact that the FIR against Teesta Setalvad is from January 1, 2002 up to June 15, 2022? In other words, it even predates the Godhra killings and it covers a span of over 20 years.
Yes. Is it June 15 or June 25?
The Indian Express reported it as June 15, but it may well be June 25.
Well, if it is June 15, it makes a lot of difference, because it is an indication that the police had already made up their mind that they're going to prosecute Teesta for something that she has done up to June 15, which also could mean that they had an inkling of what's going to happen in the Supreme Court. So I think that date of June 15 or June 25 is of some importance. But that apart, to have the span of 20 years, I think this is it's very obviously vindictive. The Supreme Court did not say, or did not even hint, or did not even suggest that, listen, you go back into her history and find out what has happened. That plus the fact that the FIR has mentioned in some place that they're going to look into how she received funds and what did she do with those funds and all that. I mean, that's obviously something which is motivated.
Justice Lokur, there's something you said in that answer in the first half that is particularly disturbing. If it is the case, and I underline that word if, because I know you weren't saying it is the case, but if it is the case that somehow the police had an inkling of what was going to happen in the judgment and had perhaps already decided to prosecute her for something that happened before June the 15th, that would be very disturbing. That would suggest that somehow the police had been informed in advance of the judgment, and that would be a betrayal of all the standards you expect of Supreme Court judges.
Yeah, no, not informed. But, they could have, or their lawyers could have made an intelligent guess and informed them that, listen, this is what we think is likely to happen. So you better be prepared, because she has to be fixed.
But if lawyers make an intelligent guess, they would do it on the basis of what judges have been saying, on the basis of comments judges have been making, on the basis of suggestions judges have been putting to them. And
Right.
once again, that sequence of events is disturbing, because one would hope that never is a case conducted in such a way that the police end up getting tipped off in advance of what the outcome could be.
Yeah, you're right. You see, sometimes when lawyers argue a case, and depending on the line of questions that are being asked, the lawyers can figure out. It's not difficult. The lawyers can figure out which way the judges are going. Okay. So in this particular case, it is possible that the lawyers figured out, that they're going to succeed, and that the report of the SIT is going to be upheld. Right. And so they probably advised the police that, okay, this is what is going to happen. And the police would have taken a decision that if this is what is going to happen, then this is what we are going to do. That perhaps could be the sequence of events. I don't know. It's just, guesswork.
All of which is even more disturbing for the audience to listen to. Let me at this point quote some of the comments about this judgment. The Oxford scholar Gautam Bhatia has tweeted, and I'm quoting him, Indian Supreme Court's contribution to global jurisprudence is to decide an individual versus state case by telling the state to arrest the individual. A remarkable constitutional innovation, he says. As a former Supreme Court judge, how do you respond to Gautam Bhatia's comment?
Yeah, well, the Supreme Court does not say, I don't think any court says, any constitutional court says, that, listen, you arrest a particular person, right? That's the job of the police, whether the police want to arrest or they don't want to arrest. If they decide to arrest, the person can come to court, and the court can then decide, whether bail should be granted or should not be granted. But I've not come across a situation where the court says, oh, you arrest this person. Unless that person has, committed contempt of court or something, in which case the court says, well, we are sentencing you to, a day's imprisonment or a month's imprisonment, in which event the police has to arrest that person.
But
so, yes, I think right. Yeah, sorry.
And in this specific instance, the court has actually said that people who they claim abused process need to be in the dock and proceeded with in accordance with the law. In other words, that is a somewhat elaborate way of saying arrest them, prosecute them, and bring them before us.
Yeah, that's what I have written about. That did the Supreme Court intend it, right? Did the Supreme Court intend the arrest? Did the Supreme Court suggest the arrest? Either way, if the Supreme Court intended it or the Supreme Court suggested it, it's wrong. Okay, I have no doubt about it.
And you also said at the beginning of this interview that if they did not intend the arrest, they should direct unconditional release. You said they could have instructed the Secretary General of the Supreme Court to issue a statement clarifying, and you were disappointed and disillusioned. That has not happened.
Right.
Let me at this point quote Amnesty International. It's one of the world's most highly regarded NGOs that defends human rights and human liberties. This is what they've said. Detention of prominent human rights activist Teesta Setalvad by the Indian authorities is a direct reprisal against those who dare to question their human rights record. It sends a chilling message to civil society and further shrinks the space for dissent in the country. This is a reprisal against people who challenge the government's human rights record. It's a terrible thing for anyone to say of any democracy.
You're absolutely correct. Yeah, it's extremely unfortunate. It's very unfortunate. And that is the reason why the Supreme Court should say something, one way or the other. That no, we did not intend it, or yes, we did intend it, and it's happened. So what?
Can I ask you this? With every successive day of silence, and we've had 3 days of silence, we're into the fourth, does the silence get more damning for the Supreme Court?
It does. Already there are so many, voices that are critical of the judgment, well, I think something needs to be done about it. And the longer,
sorry, carry on.
Yeah, and the longer this silence remains, things are not going to improve.
That is a very important point to say. The longer the silence remains, things won't improve. In fact, let's be honest, sir, they'll get worse. She'll remain in jail. God knows how she'll be treated by the police. For her, things will get worse. Not just not improve, they'll get worse.
Yeah. You see, one more thing, in view of the observations of the Supreme Court, it's going to be very difficult for a judge to grant her bail. They'll say, well, the Supreme Court said it, we can't grant bail in a situation like this. That's going to be very difficult for her.
In other words, unless the Supreme Court steps in and reverses what it said and issues the statement that you believe they should, Teesta could face the prospect of being in jail, refused bail for a very, very long time.
Yes, it could happen. Certainly.
In other words, she faces grave injustice. And I'm saying that deliberately, grave injustice.
Yeah, you're right. You see, put yourself in the shoes of a magistrate, right? The prosecution will come before the magistrate and say that, listen, this is what the Supreme Court has said. Are you going to release her on bail? The magistrate will say, forget it. If the Supreme Court thinks and suggests or intends that she should remain in jail, well, let her remain in jail. I'm not going to, grant her bail. And then she goes to the High Court. Perhaps the same thing might happen in the High Court. So that's why, I think she's in for a long haul.
Let me at this point remind you of what the Supreme Court said about Narendra Modi and his Gujarat government in April 2004. Today, the Teesta Setalvad judgment makes it clear that the same court is dismissive and critical of questions that are raised against Narendra Modi and his government of the time. But in their judgment of 12th April 2004, Justices Durai Swami Raju and Arijit Pasayat called the government, and I'm quoting, modern day Neros looking elsewhere when best bakery and innocent children and helpless women were burnt. And then it added, and they were probably deliberating how the perpetrators of the crime can be saved or protected. 4 months later, the same Supreme Court reopened over 2,100 out of 4,600 cases and transferred each of them out of Gujarat because they didn't believe justice could be done in Modi's Gujarat. Now, I admit that was 18 years ago. But has the Supreme Court forgotten the strong words it spoke? And those were not obiter dicta, sir. They were in a written judgment. Has it forgotten the strong action it took? In 2022, it seems they've forgotten about 2004.
Yeah. You see, it's like this. I think some of those comments were also, a little over the top. Okay. But transferring a case out of the state of Gujarat or transferring 2,000 cases out of the state of Gujarat is a very telling act. Now, if that is the position, the Supreme Court should have kept that in the back of its mind, that things were not as they should be. And therefore, it is possible that some of the things which were pointed out by the amicus curiae in the, which have been referred to in the judgment in the annexure, should have been taken a little more seriously by the Supreme Court. After all, the amicus curiae had no axe to grind. Okay, the SIT had a job to do. Well, they did it, but certainly not the amicus curiae. So the Supreme Court should have, kept all this in the back of its mind while deciding the case. Unfortunately, it did not.
This leads me to the question, and I suppose it's an obvious question. Normally, we in India look to the courts, and we look particularly to the Supreme Court to stand up for the rights of the individual against the might of the state. Here, it seems The court is using the might of the state to crush the rights of an individual because it disapproves of that individual's complaints. Is this a black day for the Supreme Court?
It is, well, black, you could say, certainly gray. Certainly, very gray, a darker shade of gray. But it's wrong, whichever way you look at it. I think the Supreme Court should not have gone to this extent.
The interesting thing is you didn't rule out the possibility that it's a black day. You prefer to call it. You didn't rule it out. Am I right?
I don't rule it out. No. Well, something worse can happen. One doesn't know.
Just as there are darker shades of gray, there are darker shades of black. What do you make of the fact, Justice Lokur, that none of the three judges on this bench signed the judgment? I know that happened in the Yodhya case too, but it's happened again. What do you make of that?
No, I'm not aware of this. Their names are there in the judgment.
But it was reported in the press, and I'm quoting the press, that none of the judges signed the judgment. It's possible that the press reports are inaccurate, but I'm relying on press reports of yesterday's papers.
Yeah, well, the names of the three judges are there in the judgment, so they must have signed it.
Well, the names of the judges in the Yodhya case were also there in their judgment, but they didn't sign it. Even the author of the judgment in that case is not known, although we all have guessed who it is. Could it not be the same as happened here? We know who the judges are because they sat on the benches, we saw them, they were identified. But if the papers are correct, as they reported yesterday, they didn't sign it. If that is the case, what do you make of it?
If that is the case, I'm stunned. That's all I can say.
Finally, you've been a very proud member of India's Supreme Court, and rightfully and justifiably so. How would you describe your response to what the Supreme Court said? I know I've asked you that question earlier. You said you're disappointed. You said you're disillusioned. But let me go one step further. Has the court, something that you've dedicated the best years of your life to, has the court diminished itself and let down its admirers and supporters?
Oh, yes, it has. Certainly, it has. Yeah, I don't think any person, would have expected this from the Supreme Court. Any person versed in the law would not have expected this. Particularly that paragraph that you quoted about these people being put in the dock. It's very, very unexpected.
Justice Lokur, I thank you for your openness, for your bluntness, and for telling me so forcefully that the Supreme Court should issue instructions to the Secretary General of the Supreme Court that they did not intend for Teesta to be arrested. A clarification is essential, you said, and if it doesn't come, then with every day of silence, the silence becomes more damning. And of course, the situation for Teesta becomes more unbearable and horrible. I thank you for this interview. Take care, Justice Lokur. Stay safe.
Yeah, thank you. Thank you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Thank you for your time. Goodbye.